Hello, everyone. Thank you very much, Sebene. I'm Bernita Haynes. I'm a senior attorney at National Consumer Law Center. Just real quick about National Consumer Law Center. We're based in Boston, Massachusetts, with another office in DC. I, however, am located in Atlanta, Georgia. We've been around since 1969, working on behalf of consumer justice for low-income consumers and other disadvantaged folks. Won't go into much detail here about my background, but my expertise is in medical debt as well as energy and utility affordability. So very quickly, before we jump into the meat of this presentation, I want to make sure that we kind of set the ground here and lay the groundwork for what hopefully folks will learn from today's webinar. We're hoping that today you will gain a better understanding of the demographic impacts and consequences of medical debt nationally, as well as in California particularly. Learn about existing federal protections for patients, learn about recent state bills, laws, and policy opportunities, and about how to leverage existing protections and laws. After I finish, I'll turn it over to Joy, a senior health attorney at Western Center on Law and Policy, where she'll discuss more on how to leverage the protections in California, look at what gaps are still there, and highlight some opportunities for strengthening California protections against medical debt. So, without further ado, let's jump right into it by starting with a quick glance at the impacts and consequences of medical debt. So it may surprise nobody on the call, but it may surprise many people that Californians currently owe more than $10.5 billion in medical debt. LA County residents are significantly impacted, in particular, by medical debt, with about 1 in 10 LA County adults carrying medical debt. I should note that the Department of Health believes that number to be higher than 1 in 10 in LA County adults. Many of these families can't afford basic necessities like rent, groceries, utilities, etc., because of medical bills. With recent federal policy changes to healthcare coverage as well, the problem is likely to get worse before it ever gets better. So debt collectors contact people about medical debt more than any other type of debt. Medical debt can lead people to avoid healthcare and develop mental health problems from just the stress of having these kinds of financial woes, and not to mention just all the adverse consequences that folks face when they're dealing with aggressive debt collections. Can literally exacerbate people's housing stability, you name it. So unless prohibited by state law, and luckily some of these are prohibited by California law, unless prohibited by state law, aggressive debt collection actions can include garnishment of wages, seizure of bank accounts, property liens, even civil arrest warrants for failure to appear in court. Again, the good news is that California law limits most of these actions to some extent, including wage garnishment, property liens, and charging of interest or fees on medical debt. And I'll talk more about those specific limitations in California later. These kinds of debt collection actions are often disproportionate to the debt owed. For example, in a study looking at hospitals based on gross income, gross revenue, 26 of the top 100 hospitals took legal action against patients to collect unpaid medical bills between 2018 and 2020. So in that time period, hospitals filed over 28,000 lawsuits and over 10,000 wage garnishments and liens. Most, over 60% of those hospitals, were nonprofits, meaning they have a requirement to keep their tax-exempt status to offer financial assistance. In Maryland, in particular, the debts that were sued were generally around $900. So that's what I mean by the fact that these actions are often disproportionate to the amount of the debt owed. Folks are literally dealing with wage garnishments, liens on homes, and things like this for like under $1,000 on average that's owed to hospitals. Now, as I said, California has some very significant protections that I'll expand more on later. Medical debt, while it impacts everyone, does impact certain people more. Young adults who are more likely to be uninsured, people with low incomes, Black and Hispanic people are all disproportionately more likely to have medical debt. The chance of being uninsured is actually higher just generally among Black folks, people with low incomes, as I said, young adults and Hispanic folks. Veterans and older adults, to some folks' surprise, are also significantly impacted by medical debt. That is less surprising once you realize that chronic illness is the other leading risk factor associated with medical debt, besides being uninsured. So I will not speak too much about the racial health gap and the racial wealth gap, but I do want to note that they intersect, right? So the racial health gap really refers to this kind of circumstance that we see in this country where chronic conditions like cancer and heart disease and things like that more disparately impact BIPOC families. And these individuals also are more likely to be uninsured. Two things, chronic illness and being uninsured, that are the highest causes of medical debt. The racial wealth gap intersects with it in the sense that BIPOC families, particularly Black and Latinx households, have lower wealth than white families. So when medical bills inevitably land on their doorstep, they're less likely to have the money to pay these bills, or to have a relative they could borrow from to pay these bills, even if the bill is only $500 or $600 or $700, right? That could throw some of these families into a financial tailspin. There are obviously longstanding racism, systemic racism issues that underlie these disparities as well. Before moving on from this slide, I do want to just emphasize that last line there. Medical debt, especially due to cancer, is still the leading reason that people file for bankruptcy. That's despite the Affordable Care Act, despite the various state level protections and so forth. Medical debt is still the number one reason people file for bankruptcy, and cancer is often the reason for that medical debt. Lastly, on older adults, one of the reasons that they are often very impacted by medical debt is because, besides having chronic conditions, they often have multiple insurance plans, which can lead to a lot of billing errors and billing confusion, and putting them on the hook for medical debt that they actually shouldn't owe. So multiple health plans like Medicare regular, and then Medicare Part B, all of that causes a lot of confusion. Medicaid and Medicare folks, dually eligible people, that creates a certain level of confusion as well when it comes to billing, which can contribute to older adults having more medical debt. So moving on from the doom and gloom, let's look at some of the protections that are available for Californians. Now, I want to emphasize that these protections fall into a couple of categories. Upstream, which really refers to protections that prevent people from incurring medical debt in the first place, and downstream, which refers to protections for folks who've already incurred medical debt, so debt collection protections, etc. So at the federal level, the Affordable Care Act requires that all public and privately owned nonprofit hospitals with 501c3 status provide financial assistance or charity care to low-income patients in order to maintain their tax-exempt status. Charity care or financial assistance can mean a bill being canceled entirely or partly. It can also refer to discounted care. Unfortunately, the ACA's charity care requirements have some significant shortcomings. For example, it provides no specific guidelines and minimum eligibility criteria. It also has very insufficient enforcement. Enforcement is entirely left up to the IRS. And as far as I know, only one hospital has ever lost its tax-exempt status for failure to comply with this requirement. The law authorizes no private right of action in terms of enforcement either. But the baseline protections provided in this provision of the ACA give a layer of protection that California and other states have improved upon. So it is a floor, and many states have gone beyond it to protect their residents. So let's look a little bit at what California has done. California law requires hospitals to provide free or discounted care to uninsured patients or patients with high medical costs who have incomes at or below 400% of the federal poverty level. This is actually pretty much the most generous income threshold in the country as of now. California law also prohibits inclusion of monetary assets when determining eligibility. So high medical costs, in case you are wondering, includes those of patients who have annual out-of-pocket costs at a particular hospital exceed 10% of the patient's family's income. So that's what high medical cost refers to, what their out-of-pocket costs are in relation to their income. Hospitals in California, furthermore, cannot charge financially qualified patients, so charity care eligible patients, more than what they receive from Medicare, Medicaid, or any other government insurance. They have to bill it at that rate. Hospitals may determine that a patient is presumptively eligible for financial assistance based on other information or prior eligibility. So in a nutshell, the California charity care law does essentially require free care for some people and discounted care to others, depending on their income. Overall, hospitals have to offer at least discounted care to everyone under 400% FPL, federal poverty level. There have been some other important bills in California over the last few years relating to selling of medical debts to third-party debt collectors, protecting people from ground ambulance, surprise medical billing. I'll talk more about that. But California has gone a long way to protect their residents from medical debt. So kudos. I wish coming from Georgia, that we had such protections, but we'll get there eventually, hopefully. Fingers crossed. Let's look at some of the federal surprise billing protections in particular here. So since January 2022, the No Surprises Act has been in effect to protect people from surprise out-of-network medical bills. Surprise bills or balance billing occurs when a patient receives a bill from a provider that's not in the patient's insurance network. Typically, this happens when a patient receives emergency services or has a scheduled procedure at an in-network hospital or ambulatory surgical facility, but then they're seen by a provider, a person in that hospital who's not in network. Unexpected or surprise medical bills from out-of-network providers are a source of debt that can send many people into a financial tailspin, especially older adults who are on fixed incomes. So this federal act is the floor upon which states like California have built additional protections. These federal protections are pretty basic. They ban surprise billing for emergency services, including air ambulance services, but not ground ambulance services. They ban surprise billing they ban high out-of-network cost sharing for emergency and non-emergency services, and so forth. There has to be advance notice as well in certain contexts. Now, California in 2023 decided it was important to protect their residents from ground ambulance services and those kinds of medical surprise billing situations as well. It may not be apparent to some folks on the call, but ambulance bills tended to be where much of the crazy high surprise bills would arise from. And ambulance billing could end up being $45,000 on average. And the federal law banned those kinds of surprise billing. So ground ambulance services similarly can go into the thousands, and they're often out of network. So California passing this extension of their surprise billing protections is really critical to making sure that people don't end up with these kinds of surprises in the mail, just because they had the audacity to end up injured or sick and need to be rushed to the hospital, right? Another protection that California has relates to medical debt credit reporting. The CFPB's Consumer Credit Panel convened a few years ago, and they conducted a study on the removals of medical debt collections from credit reports. What they found is that people experience like a 25-point increase in their credit score on average in the first quarter after they had a medical debt collection removed from their credit report. This average was higher for folks if the medical debt that was removed was over $500. So despite all the hubbub at the federal level and the rolling back of the CFPB's rule that banned medical debts from credit reports, states like California have taken it upon themselves to ban medical debts from credit reports. California joins 14 other states that bans medical debt from credit reports. That includes Colorado, Connecticut, Delaware, Illinois, Maryland, etc. It's mostly blue states right now, but one purple state, Virginia. Hopefully that'll change. Keeping it moving. So Protections against aggressive debt collection. Here is where we get to some of the, along with credit reporting, some of the downstream protections, what to do to help folks who already have medical debt. One way is to keep them off credit reports. Another way is to actually prohibit certain types of really egregious debt collection. So as noted, California has some limitations on wage garnishment, property liens, and detainment for medical debt. Detainment, in this case, refers to situations where a hospital may choose not to discharge a patient until the bill is paid. It sounds crazy because it is, but that is outlawed in California. You can't detain a patient or refuse to discharge them just because they haven't paid a bill in California. California also prohibits hospitals from adding interest to medical debts and from enforcing liens against a family home when it's an indigent patient residing there. There are some protections as well against wage garnishments and liens for anyone who would have been eligible for charity care. Let's take a real quick glance at some robust laws in other states. Again, these are downstream and upstream. Colorado has capped interest rates on medical debts at 3% and put in place some other protections around debt collection of medical debts. I think it was 2023 that Colorado banned medical debts from credit reports and may have been the first state to do so, actually. As mentioned, California also bans medical debts from credit reports. Delaware prohibits late fees and interest on medical debts. Florida set a statute of limitations around collecting medical debts to 3 years. Illinois has a really great standardized procedure for hospitals to screen people for financial assistance or charity care. Similar protections will be going into effect in California around 2027. Illinois also has some really, really important guardrails around medical credit cards and medical payment products, which I have not talked about in this presentation, but will become an increasing problem as Medicaid cuts set in. Maine made it an unfair practice for debt collectors to charge fees on or interest on medical debt. So similar to Delaware's protections. Maryland has some really great protections on financial assistance as well as debt collection. So prohibiting wage garnishments and liens, also requiring hospitals to reimburse patients who would have qualified for financial assistance but weren't offered it at the time. So pretty good incentive to make sure hospitals actually provide financial assistance. New York bans wage garnishment and liens, among other things related to limiting interest on medical debts. North Carolina has taken a really novel step to address medical debt issues in their state by taking executive action. Their previous governor. I strongly encourage you, when you have these slides, to click on the Learn More here and read all about this. We haven't seen any state do anything quite like this yet through executive authority. Oregon, I love what they did in terms of screening requirements. I think they were the first to do it, but they did recently roll back their own screening requirements. Now a patient has to hit the $1,500 threshold in order to be screened for financial assistance upfront. Very unfortunate what's happened just recently in Oregon this year. And then, as you'll see here, some of the protections in Maine for uninsured patients and financial assistance. So just want to make sure that you all see that there's been a lot of activity at the national level across the states to help people avoid the crisis that is medical debt. And California has been one of those states taking the lead. I want to leave you here with just a few additional resources that these are hyperlinked. So when you get the slides, you'll be able to click on them and see them. Please do take a look and know that I am always available to reach out to. But now I want to stop and turn it over to Joy to talk a little bit more about California protections.
Good afternoon, everybody. Hang on just a second and I will load up our slides here. Okay. Can everybody see that? Bernita, if you can give me a hands up.
Yeah, looks good.
All right, awesome. Okay, so here we go. My role now is to pick up where Bernita left off, and let's talk about strategies for dealing with debt once it's incurred. So my name is Joy, and I am with Western Center on Law and Poverty. We are a we are a legal services support center and policy advocacy organization serving low-income communities in California. Our primary mission is to secure housing, healthcare, and a strong safety net for all Californians. A little bit about me there. Y'all can read that if you'd like to when you get your packet. So we're going to start with some general considerations about medical debt. So the first of those is that it matters, the type of debt can often determine the best path forward for dealing with the debt. So if it's hospital or emergency physician debt, there's an excellent possibility of a non-judicial resolution if the client qualifies for charity care, because charity care law applies not only to emergency departments, hospitals rather, but also to emergency physicians, the doctors who work in emergency departments. It can also be stretched in some cases to apply to other doctors that work in hospitals in an emergency situation, such as radiologists, lab, things like that. But that's a discretionary matter. It's not in the law, unfortunately, but you can often successfully argue that. For doctors' offices and other medical providers, negotiation is possible, but your defenses are only contract and collection defenses. For dentists, negotiation is unlikely because they know they've got the corner on the market, but it is possible. And you have contract defenses plus defenses related to medical credit card rules found in Business and Professions Code 654.3. And again, we didn't talk about those, but those are a lot of protections that apply to medical credit cards generally, but are really geared toward dental offices. The last is if Medi-Cal was active at the time of service, a provider may not bill a Medi-Cal recipient, period, full stop. So I'll talk a little bit more about that as we go. Who holds the debt matters in your strategies, because if it's a medical provider, they just want to get paid. So they will negotiate, often make payment plans, just try and get the money flowing. If the provider is the plaintiff in a litigation, you must deal with that provider's attorney, who may, of course, be open to negotiation. If the debt has been assigned for collection, that is, it's still held by the original owner of the debt, but they have assigned it to a collection agency for purposes of collection activity. It's easier to negotiate directly with the provider if the provider will allow it, especially if the client can pay a lump sum. Recall that the debt is still held by the provider, and sometimes you have to convince them of that because they're like, oh, no, I sent it over to collections. We don't have it anymore. They can absolutely still deal with it. If you are going to deal with the provider and leave the assignee out, you might want to consider hiding this from the assignee, because they sometimes will jump in and call the provider and make all kinds of threats to make the provider stop talking to you. So that's something that you can give a try. In litigation, you can completely ignore or go around the plaintiff, i.e. the assignee's attorney, because the provider is not represented in the action. So the attorney who has filed the lawsuit is representing the assignee. They are not representing the provider. So you can go ahead and talk to the provider and still try and get things resolved that way. If the debt has been sold to a debt buyer, then the provider no longer has any power over it, and talking to them won't do any good at all. With the exception of if charity care is invoked. There are rules under California charity care law that requires debt to be returned to hospitals if charity care protections are invoked. Generally speaking, debt buyers have more regulations, usually more options for quick resolution, because their business model is an assembly line. They prefer avoiding court entirely. So we have pre-litigation strategies, and then of course we have litigation. So under pre-litigation strategies, first thing you always want to ask is, does the client recognize the debt? Because occasionally it's not theirs. Occasionally there's a mistake, there's a cross-contamination of common names in hospital records, so it may actually not be theirs. In those cases, you may need to contact the provider for specific medical details to remind the client of services they received, and to confirm that it truly wasn't theirs. The other element there is that debt may belong to a family member. Bear in mind always that parents are always jointly and severally liable for minor children's medical care, even if they were never married or both parents are not in the home. Spouses and registered domestic partners are responsible for each other's medical care received while they're legally married or in that registered domestic partnership. meaning any care received while they're in the relationship, also potentially meaning bills that go into after the relationship ends. So the bill was incurred during the relationship, but now the relationship is over. You'll sometimes, unfortunately, need to look into separation agreements, and sometimes it gets a little sticky dealing with divorce and those kinds of things. But nonetheless, they are, in fact, mutually responsible for one another's medical care. Adult children are not responsible for their parents' medical debt, though there is a caveat about that. See in the family code. That has to do with an old law that's still on the books that says that children are responsible to see to the basic needs of their parents to the limits of their own ability. It's never been enforced that I can find. Nonetheless, it is there. So just keep that in mind. And then the last item about recognizing debt is the signer of admission forms at a hospital or at a skilled nursing facility, for instance, are not responsible for the bills. Although an argument can be made if financial responsibility was clearly spelled out. This happens occasionally in nursing home bills where somebody will sign a patient in and will sign, yes, I will accept responsibility for the bills. However, it's still really easily arguable, and you can get into some litigation strategies on that. The next question is, are there other payers? Did the client have insurance that should have paid? Could the insurance still pay? We always recommend to try and appeal a denial or a late lack of filing a claim, even if it's too late. If the denial was egregious, consider threatening to bring the insurance provider into future litigation, if you're prepared to do so, of course. And self-funded ERISA plans can be convinced to intervene at any stage. When I was working direct service, that was actually one of my favorite situations, because when somebody has a self-funded plan, it means they work for a big corporation or a city or a county, and you can go directly to the C-suites in that county or corporation and plead your client's case directly to them, and they will often step in to pay the bill, especially if the client is being sued. The other consideration about payers is, was the debt part of a personal injury or workers' compensation claim? If it was, you can go back to the original attorney or the original workers' comp office that handled the case, and they may still handle it. But you need to be careful of subrogation claims and medical set-aside accounts. So if somebody has a personal injury claim or a workers' comp claim settled, they may have actually been given money to pay these debts, which unfortunately most folks don't use to pay their debts. And so your client may be stuck. You need to be mindful of, some bills that your clients receive are actually subrogation claims. Those often come from Medicare and Medi-Cal, in that Medicare, Medi-Cal hears there was a settlement paid, and sometimes years later will come back and say, excuse me, we need our bills paid. And of course, your client doesn't have money at that point. So there are some tricks about that I won't get into, but just sort of keep that in mind, that there are some special ways to deal with that. For medical and dental office bills, always check for balance billing. California law only applies to plans that are regulated by the Department of Managed Healthcare and the Department of Insurance. However, the Federal No Surprises Act applies to all plans. Some providers will negotiate discounts for uninsured patients, typically down to the insurance rate. Most providers are willing to enter into a payment plan if the debt has not already gone into collections, or if it's not too far away. The phrase we like to use is making regular payments of a reasonable amount. So even if the office won't agree to a payment plan, if your client begins making regular payments of a reasonable amount, the provider will usually keep the debt there and not send it to collections, and they will usually not incur interest. Keep in mind always that patients cannot sign away their rights to legal protections, such as Medi-Cal billing. Even if the client goes and signs a paper that says, if insurance doesn't pay, I'll pay. In certain circumstances, that doesn't matter. So just sort of keep that in mind. For hospital bills, I call actionable provisions of the Hospital Fair Pricing Act. And by actionable, what I mean is not that you can sue under them, just that you can take action if they're violated. Hospitals must have policies providing both free care, charity care, and reduced cost care, discounted care, to folks whose income is below 400%. So some hospitals, with a recent change in the law, we split charity care from discount care, and they think that, well, we don't have to give free care, we just have to give a discount. That is no longer the case. So if you've got a hospital saying, well, we don't give free care to anybody, you've got a way to attack that. Applications must be accepted and processed at any time. No deadlines allowed. We used to get that a lot as well. Oh, it's too late. It is never too late. Medi-Cal share of cost may be waived under charity care or discount payment policies. That was also a new change in the law, but hospitals still refuse, believing it to be illegal under federal kickback statutes or Medicaid rules. So that is a may, not a must, unfortunately. Any restriction that is not authorized by the Hospital Fair Pricing Act is forbidden. So residency restrictions, citizenship restrictions, this only covers emergency care. This only covers bills incurred in relation to not covered in certain surgeries, things like that. None of those restrictions are allowed. Assets may not be considered, but for Medicare patients, hospitals can ask. And that has to do with federal regulations on hospital bad debt reimbursement, not on waiving the costs in the first place. So if hospitals waive Medicare bad debt, they can get repaid for it if the consumer meets certain qualifications. So they are allowed to ask to see if the patient meets those qualifications. Hospitals must provide eligibility determination letters. That is frequently abused by hospitals. They just don't say anything at all, or they call the patient up and say, sorry, no good. Must provide that eligibility determination letter. And the maximum discount care charge is the amount the hospital would expect in good faith to receive from the highest paying public program they participate in, which is typically Medicare. And then I note that HCI is on the case, sort of. That's the Office of Healthcare Access and Information. They were just a few years ago tasked with actual enforcement of the Hospital Fair Pricing Act, which we had never had before, but they are incredibly overwhelmed and they have very few folks, and they are also still struggling to figure out the regulations, figure out how they're going to do this. So unfortunately, it gets a little weird over there. So on the collection side, hospitals are prohibited from sending unpaid bills to collections when the patient is attempting to settle their bill, unless the collection agency has agreed to comply with the HFPA. No liens on primary residence or garnishing wages if patients are eligible for financial assistance. And eligible for is the key phrase there. It's not that they have applied for and been approved. It's that they're eligible for. So you can go back and get those things or some protections for patients by showing that the patient was eligible for protections, even if they didn't apply. Collection agencies can garnish wages, but must comply with specific procedures that make it a lot more complicated. Reasonable payment plan terms and no interest requirement are still apply after the transfer to collections. Again, if the patient is financially qualified or eligible under the policies, regardless of whether they ever applied. You also may and should be able to apply these rules post-judgment or at renewal of judgment. We've had some success in that if charity care was not considered. Debt buyers, no interest, no fees, and there are some special rules that apply to medical debt collection. Coming soon to a hospital near you, AB 1312 will require, effective July 1st, 27, proactive screening for uninsured patients, those with high deductible plans, or anyone who's going to have a bill over $500 needs to be screened for assistance before discharge. Hospitals are still trying to figure out how they're going to do that, but that's what the law says. And then also it makes presumptive eligibility for folks who are enrolled in public assistance programs or who are experiencing homelessness. Most policies already included that, but that AB 1312 will add that to the law. The reasonable payment plan definition is in there, and I'm going to sort of skip over this, but it's just that hospitals have to comply with this reasonable payment plan rule. Key considerations for financial assistance in pre-litigation. Did the consumer apply for financial assistance? If yes, when did they do it and what was the outcome? You can appeal. If not, apply now, even if litigation has commenced. Any verbal communication with hospitals about the bill, if the consumer called the hospital and said, I can't afford to pay this, and the hospital didn't offer them charity care immediately, that puts them into that eligible or financially qualified rules that you can go back for. Unless an application was legitimately denied based on finances and a client is still over the income limit now, apply and appeal denials as appropriate all the way to the C-suites. Question, did the patient have Medi-Cal? As I mentioned, if the patient had active Medi-Cal at the time of service, or if it was made retroactive to the time of service, Medi-Cal providers and their collectors cannot bill the patient, period. That's it. So if the consumer told the provider they had Medi-Cal, if they showed the card to the provider or provided their Medi-Cal information at any point in the process, doesn't matter if it's on the day of service, but at any point, if they told the collector they had Medi-Cal, that's it, no billing. There are sanctions for inappropriate billing by Medi-Cal providers or collection agencies of 3 times the Medi-Cal reimbursement rate. Nobody is enforcing this, but it's a really useful threat in a demand letter. Collectors are obliged to cease debt collection efforts upon receiving proof of Medi-Cal. The hospital has to notify ancillary services of Medi-Cal eligibility. That's going to be your ambulance providers, your radiologists, your pathologists, things like that. And the collector is required to notify the credit reporting agency. Now, that is something that doesn't really matter at this point because of our medical debt collection reporting rules. However, those rules are under lawsuits and subject to change. We hope not, but maybe. Let's see. Okay, advocacy tips for Medi-Cal billing. The collector will allege that since the patient didn't provide Medi-Cal at the time of service, it's too late to do it now, so the patient has to pay. That is absolutely false. The collector may also say that an MC 180 letter of agreement is required. This is also false. That's the thing that lets the collector collect money, but the ability to collect money is not the determination for stopping billing Medi-Cal, because the provider is responsible for conferring Medi-Cal coverage at every visit, including managed care enrollment. Other attacks on hospital bills include getting an itemized bill and checking for errors, checking for duplicate charges, making sure that when multiple visits are involved and payments have been made, the payments have been appropriately applied. Some advocacy tips for hospital debt: submit your financial assistance application at any stage of the proceeding. Bypass or ignore the collection agency attorney if the debt has been assigned. Appeal financial assistance denials. Keep in mind that a good story can bypass policy. You'll want to look for catastrophic illness or similar clauses in policies and use them. Note that depending on your relationship with the collection attorney, you may not want to let them know what you're doing because, as I mentioned, they can sometimes interfere with the process. Look for ways that the hospital's actions or policies violated financial assistance rules and threaten legal action if you and your client are actually ready and willing to take it. I threw in this slide here. It's not in your packet. It was a last-minute ad, and you're going to want to write down these statutes and regulation at the center bullet point. Because anytime a Medicare patient requests a service that a provider knows or suspects Medicare is not likely to cover, the provider is required to notify them and have them sign an advance beneficiary notice of non-payment. If they do not have them sign that, then the patient does not have to pay a denied claim. So that's a really powerful tool if you use it properly. However, keep in mind this does not apply to emergency services, including ambulance transportation to the emergency room, because of the rules about EMTALA. All right, moving on to litigation strategies. There are 3 paths forward for litigation. You can fight, you can negotiate, or you can ignore the bill. The best plan is to tell the client the worst thing that can happen and then let them decide. They're always going to want to ask, what do you recommend? What do you recommend? But really, you can't recommend. You just tell them the worst that can happen. You fight if the client can tolerate the risk, if they qualify for a court fee waiver or can afford the filing fees, and if the plaintiff violated any laws, or it's a hospital or Medi-Cal covered debt and charity care applies, if there are clear defenses, or if the act of fighting may improve the outcome, like increasing a likelihood of settlement. You negotiate if the debt is legitimate, the client has something to offer, and either the client can't tolerate the risk or there are no clear defenses. Try not to negotiate Medi-Cal balance billing, and I say try because sometimes your client will just say, I just want to pay it. So you'll want to take that into mind. And then ignore the debt and the lawsuit if the client has nothing to offer and is judgment proof, or if neither fight or negotiate are reasonable options for the client. But don't ignore Medi-Cal balance billing. because at the very least, you can send demand letters and you can make motions to make the collector stop. Under fight, your steps are identify the problems with the complaint, request a bill of particulars, advocate fiercely, consider filing a cross complaint. So the first thing to look at is, are there blatant facial issues with the complaint? Has the statute of limitations run? Are there clerical errors? Are there jurisdiction and venue errors? Are they missing? Is the complaint missing any required information or attachments? Has the plaintiff met the AB 1020 pleading requirements for hospital debt found in Civil Code 1788.185? If there are problems with the complaint, demur. It shows the plaintiff you're willing to fight, and it slows down the process, which they absolutely hate. The statute says that there are no special demurs in civil limited cases. Most medical debt is filed in civil limited. However, you can do it anyway if you do it carefully, because the collection attorney may not catch it, the court may not be bothered by it, and there's no downside other than time spent. So a general demur attacks the sufficiency of the complaint in general terms, such as failure to state a cause of action. Special demur attacks the form of the pleading, which includes bad drafting. But you can simulate a special demur in a general demur by alleging failure to state a cause of action and pointing out all the ways that the form is wrong. We have provided in your packet, a sample complaint that was demurrable, the demur that was filed, and the decision that was provided. Those are all there to take a look at. Requesting a bill of particulars. The bill of particulars is basically the itemized statement, but it's a little more, has a little higher legal burden. It shows specific evidence of the account at issue, gives you that itemized billing, may lead to court action against the plaintiff, although I've never seen it. Shows the plaintiff you're willing to work the case and are taking it seriously, but you do need to use it judiciously, considering your relationship with the plaintiff or opposing counsel. If you're somebody who works with the same collectors all the time, you don't want to hit them with it every time, because then they quickly learn this is just a strategy and they'll basically ignore you. Medical bills are contract-based, so contract defenses apply. Was the consumer under duress? Of course they were. They were at the emergency department. Did the provider exert undue influence? Did they have capacity in the moment? Was the contract in their language? Were they given meaningful opportunity to read the contract? Were the terms of the contract misrepresented? This is the one we see most often. It's a 4, 6, 8, 10, 12 page contract at the terms of admission, and the folks at the desk will say, sign this so we can treat you, or sign this so we can bill your insurance. Those are complete misrepresentations of the terms of the contract, and it gives you a defense. The contracts for hospital admissions are almost always contracts of adhesion, and those defenses do apply. A contract of adhesion, very quickly, is a standardized contract which is imposed and drafted by the party of superior bargaining strength, relegates the subscribing party only to the opportunity to adhere to the contract or reject it. And of course, people have no ability to reject a contract that's required to sign before they can get treated. There is an excellent law review article about adhesion contracts in your packet as well. I love that as an option to fight. You can always file a cross complaint. There is no private right of action under the Hospital Fair Pricing Act or the IRS regulations, but violations of either of those are predicate acts under the unfair competition law. So you can allege unfair competition. These are also violations of the Fair Debt Collection Practices Act. Those statutes provide actual damages, statutory damages, and attorney's fees. Conduct in violation of the Hospital Fair Pricing Act, which results in a patient being subject to collection activity for a debt that should have been reduced or waived entirely, would violate several provisions of the Fair Debt Collection Practices Act and the Rosenthal Act, and the statutes are there. Let's see, cross claims related to medical billing. No private right of action to enforce Medi-Cal billing law, but again, it's unfair competition, collections violation, etc. There are no appellate cases on this point yet, but somebody's got to be the first. There is a sample in your packet of a Medi-Cal billing cross complaint. There's also a sample in there that I threw in that is a sort of unique thing that we did to try and get a person qualified for financial assistance at judgment renewal 10 years after the debt. It's sort of a primer on the Hospital Fair Pricing Act for the courts, and it worked really well for us. Always ask if collection law has separately been violated. There are a lot of laws around collection law, and we want to ensure that folks are being protected. Post-judgment, successful application for financial assistance requires setting aside the judgment, stopping garnishment, removing liens, and refunding the money that has been taken with interest. Also keep in mind that prevailing party attorney's fees are available if a case is dismissed before judgment. Not sure why that's quite here on the slides, but there you go. All right, if you can't fight, negotiate. Enter into a payment plan if the debt is legitimate with no effective defenses, if the client can afford to make payments, if the debt will eventually be paid in a reasonable time frame, and if a formal settlement agreement can be made in writing. I say that was not necessarily a deal breaker because some collectors just simply refuse to do it. So you can discuss with your client the risks of not having it in writing and go ahead and do it anyway if they're willing to take those risks. Negotiating a payment plan involves determining how much the client can reasonably pay each month. Try to get the plaintiff to reduce or eliminate accrued interest or attorney's fees. That's usually where they'll go because they just want to get their principal and their costs. So they will typically do that when you're negotiating a payment plan. Some amount of lump sum up front is the best incentive to get this going. So if your client has anything to offer, a lot of folks get sued in December and in January because tax refunds are coming and collectors know this. So that's always a good opportunity, a good time of the year to get a payment plan or just pay it off by a lump sum. Do not allow in your negotiation for penalties for missed payments, additional interest to accrue beyond what's already accrued if the collector won't waive it and if it's allowed under the law, or liability for other parties. Be sure to make the plan term as short as the client can afford, because the longer the plan, the less likely your client will complete it, and then they'll be right back where they were when they started. The last option is to ignore it, which is a legitimate option in many cases. So again, educate the client about the worst that could happen and then tell them what will likely happen. Talk to them about enforcement of judgment. Garnishment, levies, and liens all have limits under the law. Talk to them about how long a judgment lasts and how much interest will accrue. And in case folks aren't up on it, in 2023, we changed the law applying to medical debt. So a debt can only be renewed once for 5 years and interest is capped at 5% instead of the statutory 10%. That means that a judgment in medical debt, the absolute maximum time it can last is 15 years, and then it's done. Let your clients know that there is no debtor's prison in California, because believe it or not, there is still debtor's prisons in other states. And so folks may not know that that's not here. For seniors especially, let them know what happens to a judgment after death, because seniors will frequently be concerned about their heirs. Give your client permission to ignore it if it's their best option, because this is a especially difficult thing for seniors, immigrants, and marginalized populations who are quite frequently afraid not to pay debts. And they will sometimes pay a judgment debt or a litigation debt before current medical care, food, rent, etc. Be sure that your clients know that this is the lowest priority debt they have. Last thing, what about bankruptcy? Sometimes bankruptcy is the best option, particularly when there are assets involved, or if a client may be earning decent money in the future, or when a client has other large bills, medical debt or otherwise. Bankruptcy can clean it all up all at once. However, and this is the big however, if you're not a bankruptcy attorney or trained in the subject, don't try to advise your client even of the basics. Refer them out to someone who can talk to them. We as attorneys sometimes get into a lot of trouble thinking we know what we're talking about when we don't. So don't even try it. All right, that's the end of my presentation. And the last thing is I am available should you need to contact me, and go get them. That's it. Questions for either of us? Trying to stop sharing here.
It's usually somewhere at the top of the screen.
Yep, got it. Here we go. Okay, do we have questions?
Let's look at the Q&A real quick. See if there's anything there. I do see comments in the chat. Will we be provided a copy of the PowerPoint? Yes. I see that question's already been answered. All right. Oh, we don't hear you, Joy. You are on mute.
Thankfully, it's only to right now. I thought you were reading an old comment. No, I was just commenting that I could have slowed down. I could have spoken slower because we have extra time. That's all right, though.
And so if you didn't put any questions in the Q&A or in the chat, now is definitely the time to do so in our 10 minutes here.
Okay, it looks like our host, not sure if our host is still with us or not. Aha, there we are.
Yes, thank you so much. Looks like there is a question from Lisa. If your client is a senior and can only pay $5 per month towards an outstanding bill, will the hospitals accept it?
So interesting thing about that, it has to do with one of the slides that I went over very quickly, that has to do with that reasonable payment plan. So if your senior qualifies for financial assistance, that is their income is less than 400% of the federal poverty level, they will either have it waived entirely, which is great, of course, or for those more moderate income seniors, they may end up with a discount payment. So the payment plan is negotiated between the hospital and the patient. That's what the law says. However, if they can't come to an agreement, then the payment plan is limited to 10% of what's left over after they pay all their other bills. So what that means is that if they are upside down with their bills, or if they've got, $50 worth of walking around money left every month, then all the hospital can require is 10% of that. So that $5 payment would be absolutely accepted, or would be required to be accepted, if the patient had that only $50 or less left over after they pay all of their other bills. The interesting thing about that is that sometimes that ends up with what we call a $0 payment plan, which means they don't have anything left, or they have, $10 left. And so it's a $1 payment plan, which the hospitals are not going to want to deal with anyway. And so in those cases, it's really kind of hard, especially for large hospital conglomerates, to make a $0 payment plan work, because they have to keep it in their system. They're not allowed to send it to collections, but their system typically makes accounts go to collections after 90 days of non-payment. And so it's a tricky thing. And some systems, such as Dignity and Sutter Health, are not capable of programming a $0 payment plan. And so it's something that you need to fight, and you need to fight it hard. Typically, they will file it as uncollectible if there's a $0 payment plan, which means your client doesn't need to worry about it anyway. But that's an excellent piece of the law, is that reasonable payment plan. And so that's where that comes from.
Looks like we have a couple more questions. First question, is WCLP available to co-counsel on any case?
Ooh, thank you for whoever asked that question, because yes, we are absolutely available. Please contact us on medical debt. We love to do co-counsel. We have multiple levels of co-counsel. We can just consult in the background or if you just need research help or something like that. We can come along and co-counsel alongside you, either as second chair or primary, if it's something that your organization is not able to handle. And if you have an issue that is more systemic, something that really, really needs to be addressed, but you don't have the capacity or the ability to handle it, we can take over those cases and just run them entirely. It depends on what's going on, and it's very factually dependent. But yes, we love to co-counsel. Thank you for asking the question. Please reach out to us.
Next question. How much of this can be self-help? My office has extremely limited resources for helping folks with these issues, but we'd like to give them something, even if it's just recommending they ask about charity care.
So I'll start and then let Joy jump in. A decent amount of this can be self-help, actually, assuming literacy for the particular patient that's involved. I have in my previous role before NCLC created a guide that was specifically for patients to use themselves to figure out how to get charity care, negotiate a medical bill, and a payment plan on a medical bill. Literally had one woman who was uninsured at a time that she had a minor stroke, and she got a hold of my old guide, used a little 5-point checklist I had regarding financial assistance, and managed to get all 29K of her remaining medical debt canceled. She'd had about 31,000 in medical debt from this visit. And mind you, she initially rejected an ambulance, but took the ambulance and they discharged her within hours. And she still ended up with $31,000 in medical debt. So it is very possible for people to engage, to do a lot of this and for on their own. But I do say that it's very important to make sure if a client comes to you that you think that they are capable of doing this on their own, because literacy levels definitely vary and some people just can be very overwhelmed. So, and I'll turn to Joy because I know you've had much more experience dealing with clients with these issues.
Absolutely, especially on the charity care front, it is absolutely self-help. Just need to encourage folks because sometimes they don't know, they're afraid. Is this charity? That's something that we run into quite frequently. Folks I don't want charity. I just want, a discount. So we actually don't use the phrase charity care. We use financial assistance because it's more palatable for folks. But absolutely, included in your packet is a medical debt cheat sheet for advocates, which will allow you to give some real quick advice to point people in the right direction to get started. We don't actually need typically to have advocates directly involved unless a charity care application is denied. That's really when your skills as helping with an appeal become really important. But up to that point, and hospitals are getting better. I will admit that hospitals are getting better at making sure that charity care rules are followed.
All right, last question. Do you also help with landlord/tenant debt?
Bernita?
So we do have a team at NCLC that I'm not part of that deals with landlord and tenant debt. We have a guide that I just mentioned in the chat called Surviving Debt. Then it has a whole chapter on medical debt as well as housing debt related issues. It's specifically for consumers and for regular folks to figure out how to resolve their situations without necessarily having to utilize legal assistance.
And Western Center also helps out with landlord-tenant issues, but not direct individual service to individual consumers. So we do more impact work in the landlord-tenant realm. A lot of folks, if it's happening to them, it's happening to everybody at their apartment complex. And so we can sometimes get involved in that situation. Mobile home parks is another big area for us. But so we do have a team that deals with that as well.
Yeah, another team of ours that works on things related to landlord-tenant debt is our energy team. I mentioned that energy affordability is my other area, since utility bills have everything to do with folks' ability to stay in their homes. Whole chapter in surviving debt as well related to utility bills, because that can be a real quagmire for folks. So yeah. And I believe I think I hyperlinked our surviving debt guide in the slideshow. So definitely take a look.
Well, thank you so much to our amazing presenters. That was a great, really informative training. Like I mentioned, materials for this webinar are available through the Dropbox links. Please take a look at any other of our upcoming trainings that we will be hosting. If you have a question that comes to you, please feel free to email us. That email is in the chat. If there's nothing else, then we will go ahead and end the training.
Thanks, everybody.
All right, everybody, have a great day.
Thanks, everyone.